The following workshop, Copyrights, Trademarks, and Fair Use Explained, by attorney Brad Frazier, was recorded at the 2011 Idaho Book Extravaganza.
Okay, again, welcome. Well, it's nice of you to spend some time with me on a Friday afternoon. I know it's a beautiful fall day outside. Hopefully we'll provide something to you today of benefit. And I've provided you with my phone number and my email address. I hope that you will make liberal use of that contact information, because one of my great pleasures in life is doing a seminar and having someone call me afterwards and ask me a question. And it's free legal advice. And I like to do it because I like copyright law. I'm just fascinated by it. I think intellectually and academically it's a fascinating construct. And let me tell you why I think it's so interesting. When I was a kid, my father was in the radio business. He owned radio stations here in Boise. And those old-time Boiseans may remember an old country station called KATN out on Fairview Avenue. That was my dad's. And there's a company called ASCAP, the American Society for Composing Artists and Performers. And what they do is they collect money from artists, from people who publicly perform their songs. And radio stations have to pay money to ASCAP for the privilege of paying or playing those songs. So each year the ASCAP auditors would come to my dad's station out there on Fairview and audit his books and records to make sure he'd paid the appropriate monies so that Loretta Lynn and Merle Haggard and Dolly Parton all got their money. That's literally what it was about. And I was fascinated by the concept that by doing nothing more than doing something creative like a song or a book, that you could make money from that, be paid for it, because typical constructs of revenue contemplate that you have to make and sell a tangible thing, right? Something that sits on a warehouse on a pallet has value. But you don't. As content creators, you're creating intellectual, intangible property that has value. Just as the songs that my father played, Dolly Parton got money, the works that you create as content creators have value. And the way that we protect that value, in part, is through copyright and trademark law. So our objective today is to help you identify what a copyright is and how you can best protect it, and indeed, as we like to say, monetize it. Because isn't that what this is all about? Some of you, bless your hearts, may be open source authors. Maybe you're in it for the good of the people, the good of the cause, right? And if that's the case, terrific. But there may be some of you who actually want to monetize your intellectual property, just as Dolly Parton does. Or a more contemporary example, Miranda Lambert does, or take your pick. I'm quite pop culturally literate. We can talk about Kid Rock if you want, so it doesn't really matter. We can talk about any artist that you want. My good friend Marilee Marsh is going to assist today with the clicking of the slides. Marilee, if you would please. Thank you. So our three goals today in the next hour, and we will end promptly at 4, or if not a few minutes before, is to create situational awareness so that as you are creating content, you will be aware of the issues that you encounter as an author or a content creator in this legal space. And lastly, we'll hopefully find ways to help you avoid liability. You do not want to get sued for copyright infringement. That is what I do. I sue people for copyright infringement. And I also defend people against claims of copyright infringement in federal court. Believe me, it's nasty business. Nasty, nasty business. If you can avoid it at all costs, I would encourage you to do so. And hopefully we can talk about some things today that will help you recognize your intellectual property, protect it, monetize it, and avoid liability from third parties who claim that you've stolen their intellectual property. Okay? Marilee, if you would, please. Now, as a general rule, there are multiple legal issues for content creators, and I'm, again, scrupulously avoiding just the word author because you are content creators. You may be photographers, you may be sculptors, you create content, and so thus all of these are the legal issues that I think you as content creators will confront. For example, you have, and we're not talking about all these today, this is a universe of the things I think you might think about in a legal realm. You have usage issues, and by that I mean what content out there in the world may you use and how may you use it. Content protection issues, how do you protect the content you create against misappropriation or plagiarism or theft? Content rights issues, what right do you have to use that content in different constructs or different settings? Privacy issues. Do the individuals about whom you're writing, family members, public figures, do they have any right of privacy? Are you free to write a tell-all memoir about your experiences as a child growing up in the home of a public figure, exposing to the world the fact that this public figure was an alcoholic and a child abuser? Can you do that? Don't they have a right of privacy? What about that? We're not talking about that today, unfortunately, but that's another issue you confront. Right of publicity issues. Individuals have the right to control how their image and likeness is used. Are you free to simply write a pseudo-fictional story about somebody, even though the intimation is that it's a person that we all know? Are you free to do that? Defamation issues. What if you write something about someone that's provably false and harmful about that person? You may get sued for defamation. And lastly, contract issues. When you do get that elusive book contract, or if not, you potentially would confront contract legal issues. What rights are you giving away? For example, let's assume you sign up with an ebook publisher, and the suggestion is that you give away all rights, foreign and domestic, in perpetuity. Well, what have you just given away? Do you know? And you should think about that. So there are contract legal issues here as well. This is sort of the universe of, I think, legal issues that a content creator would confront. But today will be much more narrow. Marilee, if you would, please. Today, however, we're going to be speaking about copyrights, the fair use doctrine, which I know you're all very interested in, and lastly, if we have time and interest, we'll talk about trademarks. Not as germane, but you might find it useful. Relative to copyrights, we'll talk about inbound copyright considerations, and by that I mean, how may you use third-party content that you don't create? Maybe you literally write every word that you use. Maybe you go out to the internet or some third-party source and use those materials. What are the implications of using inbound content? And lastly, the outbound copyright considerations of how do you identify, protect, defend your content so that you may monetize it if you choose to do so. So this will be our more specific theme today. If that last slide, oh, and by the way, if anybody wants a copy of the deck, just email me and I'll send you a PDF. It's not proprietary. I'm happy to share. So just email me. My email actually, thoughtfully, is on every slide. You know why? Because I have this great marketing consultant who said, when you do a presentation, put your email address at the bottom of every slide. Son of a gun, you're going to see it on every slide. Right, Marilee? Okay. So you can email me, and I'll send you the deck. And so if those topics on that last slide whet your appetite, right? Like, hey, defamation, right of privacy. Those are cool topics. Those are sexy, right? We can talk about those. All right, next slide. All right, so here we go. Let's define our terms first. Let's talk about the types of intellectual property. People, bless their hearts, invariably mix up the terminology. That's okay. These are difficult concepts, maybe. So the way to think of it is, when you build a house, you use different tools, right? You use hammers and cement mixers, maybe, and screwdrivers, and a level. 4 different tools to build a house. They do different things. You don't drive nails with a level, although I've tried it. Maybe some of you have tried it when you can't find that darn hammer. But it's not the appropriate tool, is it? They do different things. They have different purposes. And if used correctly, they're very efficient in building the house. Similarly, intellectual property has different flavors, different kinds of tools. Well, we've already lost our first class member. Sir, I'm so disappointed. That was a little bit cheeky, wasn't it? Okay, nobody else will leave now. You watch. All right, so the first thing we have, copyrights. That's one kind of intellectual property. Secondly, trademarks and domain names. That's a completely separate thing. They're not the same thing. Patents are completely different than copyrights and trademarks, and trade secrets are absolutely different from the other 3. They're all different. So if you were to call me up and say, Brad, I need to trademark my book, what would I do? I would force you to recast it into the correct terminology and nomenclature. What would I actually force you to say? That's actually wrong as well. But we'll discuss why that's wrong in just a minute. See, I set you guys up perfectly. You all fell for that. That's actually wrong as well. You don't copyright a book. Okay, we'll talk about that. They all do different things. And I'm not going to bore you with an academic discussion of the differences. Just know that they're different and use the terminology correctly. Really. So a trademark is not a copyright, it's not a patent, it's not a trade secret. They're different, and they all do different things. Today, principally, we'll focus mostly on copyrights. And as I said, if we have time, we'll talk a little bit about trademarks and domain names. But believe me, by the end of the hour, you'll know a lot about what copyrights are. Okay, Marilee. Why do you even care? You're here for some reason. Presumably, it wasn't just to hear me speak and get free legal, well, not free legal advice, but reduced price legal advice. Why do you care about copyrights? If you don't know why you care, these next 2 slides will offer, humbly, some suggestions as to why you might care. Marilee, the next slide, please. Here's one. It's just about 2 years old, as you can see, the date. But note that this gentleman, Greg Fair, pled guilty to charges of criminal copyright infringement for selling more than $1 million in pirated software on eBay. So are there any implications relative to copyright law? Yeah, it's not only a civil issue. You know the difference between civil and criminal. Those are two different kinds of TV shows. There's civil lawyers and there's criminal lawyers. That's why there's Law and Order and the other kind, right? LA Law. That's why. Okay. So we have criminal copyright infringement. So if you don't mind your P's and Q's, you can actually go to jail in the realm of copyright law. The FBI is actually very aggressive about enforcing copyrights. And if you really screw up, you can actually go to jail. So this isn't just make-believe. You know, I would even go so far as to say maybe you actually do need a lawyer if you're dealing with copyright law issues, because if you do it wrong, you can go to jail. The next slide, please. This slide is interesting as well. Check this out. Notice the date on this. What is the date? What was it, 10 days ago or whatever? Spread of ebooks may heighten piracy problem. Think about that. Back in the old days, if you were going to pirate a book, you had to go into a used bookstore and find a book and take the cover off and sneak it down to the copy center and go to Kinko's or go to your office and lay it on the copy machine and make the copies and then staple them together and then surreptitiously sell them at a flea market or give them to your buddies. I mean, there's some effort involved, right? Back in the old days. But now, with an ebook, as soon as you upload your ebook to Amazon and somebody downloads it on Kindle, immediately they start cracking the DRM. It's called Digital Rights Management. They crack it, and they print it off, and they sell it on their website. And you get nothing. You get no money. Happens every day, all the time. So if any of you have already uploaded your ebook to Amazon, and it's available on Kindle, I'll bet you a nickel that 10 minutes from now on Google, I could find it and download it for free. So, yeah, true. So it's a problem, right? E-book piracy is a huge new problem, and this is specifically a copyright law issue. It's a copyright law issue. People are infringing your copyrights when they crack, well, and Amazon, when they crack the DRM on a Kindle e-reader and download your book and print it, or manipulate it into some other format. That's illegal. So there are ramifications to you as content creators. And hopefully these two relevant slides, show that it really is an issue of interest, I think. Merrily. Okay, ask yourselves as we read these together, if any of you have ever heard or said this. I won't ask you to admit that you've actually said one of these things. I'll only ask rhetorically, has anybody ever heard any of these? Wilbur says, I copyrighted my book by putting Circle C on the bottom of the first page. Again, rhetorical. Not assuming anybody has ever done this. Jane says, oh, this quote is on the internet, so I can just right-click and use it in my manuscript. In fact, in the newest version of Windows, I understand that, you know how there are windows drop down, and when you right-click on something, it opens up a little window, so you have choices of what you want to do. Now, in the next version of Windows, when you right-click on something, the window will open, and it will say the choice will be infringe copyright as the choice when you right-click. So just know that right-clicking, generally speaking, is copyright infringement. It just is. Clarence says, I copyrighted this manuscript by mailing it to myself. Oh, you ever heard that, right? You mail it to yourself, you got a copyright? Judy says, oh, we don't have any copyrights because we've never registered anything. I never paid any money to a governmental agency. Therefore, I have no copyright. Do any of you have any copyrights?
15 years ago, they told me to do it that way.
All of you have copyrights. All of your hands should be reaching for the sky. You all have copyrights, every one of you. And we'll talk about why, but you do. And hopefully that will be illustrative of some of the misconceptions about copyright law that are floating around. This is just egregiously wrong. They're all wrong, but this one's egregiously wrong. Okay, Marilee. Key, copyright is not a verb. That is why you were all wrong earlier. You don't copyright something. Copyright is a noun. Remember Schoolhouse Rock? A noun is a person, place, or thing. This is a thing. It's an intellectual property right, incorporeal, but nonetheless an intellectual property right that springs into existence, as we say in law school, at the moment. Well, I guess I should define it. Marilee, would you please? A copyright is a property right that springs into existence when a sufficiently creative idea is reduced into or onto a tangible medium. There's the highfalutin law school definition of a copyright. It's a thing. Hi, I just saw you sitting out there. Oh my gosh, I haven't seen this. We used to work at the same law firm. It's Rochelle, right? Yeah, good to see you. Okay, so a property right that springs into existence when a sufficiently creative idea is reduced into or onto a tangible medium. If you don't have that, you don't have a copyright. But if you do have that, you have a copyright. It just exists incorporeally. It just does. So wrap your brains around the fact that this thing just magically springs into existence out of the ether, when you do that. So then, how do you create a copyright? Don't just read me back the words. How would you create a copyright?
You create an idea.
Sir, ma'am?
You create an idea.
And then?
And then you write it down.
Amen. You have a copyright. So how many people in this room own a copyright? All of you. Because you've all taken an idea and reduced it. Anybody taking notes right now owns a copyright in those notes. You do. You could literally sue people for copyright infringement based on using those notes without your permission. And I would sue them for you. Because you own a copyright in that stuff. You just do. So you all own copyrights. It's not a verb, it's a noun. You own copyrights. You create them and you own them. And you exploit them and you monetize them. And then you retire to the Bahamas. Copyright is not a verb. So you will never, ever, ever I will never allow you to get away with saying, I need to copyright this, or is this copyrighted? It's not a verb, it's a noun. So the correct terminology would be, Brad, I've created a copyright by reducing a sufficiently creative idea into or onto a tangible medium, and now I need your assistance in protecting that copyright through registration or perhaps litigation. That's what you would say to me. Okay? So the owner of the copyright is the author, and that's in quotes because that's a big deal. The author under copyright law is the person doing the reducing, or the reduction, to the tangible medium. So then let us give some examples of who the author is. When you write words on paper, you are the author. When you type words into the keyboard, you are the author. When you sculpt clay with your hands, you are the author. When you click the shutter on a camera, you are the author, not the person in the photograph. They have no copyright interest in that photograph, none. You do as the author of that photograph. However, if Rochelle, unbeknownst to all of us, is secretly recording this, because she has a recorder in her purse, and we know she does, who owns the copyright in my presentation that I'm speaking? Rochelle does, because she's the author, not me. My words aren't tangible. They're incorporeal. They're intangible. But somebody, Rochelle, is reducing them to a tangible medium, and she owns the copyright. Isn't that fascinating? By extension, the person running the video camera owns the copyright. Now, it gets very complicated when the stuff you're videotaping is not your stuff. Like if you're sitting in a theater and you're videotaping the latest movie, well, that's a different issue, right? I mean, I'm not talking about that. I'm assuming that you have the rights to create this work as an author. So to be clear, the owner is the author, and the author is the one who does the reduction to the tangible medium. So you all own copyrights. You create copyrights every day, a lot of them, if you're a prodigious and prolific author. I must write and send 300 emails a day, and each one of those is a copyrightable work. Isn't that amazing? Yeah. Okay, Marilee. Oh, and if you have questions, yeah, ma'am, go right ahead.
I just wanted you to define, can you flip that back to the
Marilee does not know how, but I know exactly what that slide says. You go right ahead.
significantly creative?
Oh, that's a great question, yeah.
How do you define that?
That's a super question. There's a very famous Supreme Court case called Feist, F-E-I-S-T. If you are in the mood, if I've inspired you to learn more about copyright law, go Google up Feist, F-E-I-S-T, U.S. Supreme Court case. And what it did is the Feist case rejected the sweat of the brow doctrine. Okay, bear with me. What that means is that now, under the Feist case, the work that you create has to have some nominal spark of creativity. And that's what litigation is all about. We fight over whether something is sufficiently creative. Let me give you some examples of stuff that's not creative. Okay? For example, if you simply went around and asked everyone in this room their name and wrote it on a piece of paper and put it in alphabetical order, that would not be sufficiently creative. The organization of a group of facts into alphabetical order is not sufficiently creative. If, however, you went around and got everyone's name, and then based on the individuals in this room, you wrote a 3-act stage play with everybody as a character, that would be sufficiently creative. Somewhere in the middle, most cases lie. It has to have some nominal spark of creativity. So as a general rule under copyright law, we say that things like databases, mere assemblages of facts, mere facts are not protectable under copyright law. What's your name? Lynn. So Lynn, let's assume that you call me next Thursday morning and you say, Brad, I had an epiphany in the middle of the night. I dreamt about the result when you take the circumference of a circle and divide it by its radius. And I want to copyright that thing. Well, beside the fact she's used as a verb, why can't she copyright the circumference of a circle divided by its radius? Because it's pi, 3.14159, and you can't copyright a fact. See? Okay, good. All right. Lynn, does that answer that?
It does.
Okay. Marilee.
Work for hire.
Oh, we'll get there. We'll get there, dear Marilee, momentarily. Yeah. Now, so when you own a copyright, remember, how do you create a copyright? You're going to all learn this. You reduce a sufficiently creative idea into or onto a tangible medium. You'll say it by the end. It's no big deal. Okay, when you do that and you own a copyright, you are the only one that can do these things with respect to that work. But wait a minute, you're going to say, but Brad, I haven't paid any money to anybody. I haven't filed any paperwork with the federal government. What, are you crazy? What do you mean I'm the only one that can do these things? That's just a function of copyright law. When you create a copyright, you're the only one that can lawfully do these things. Thus, if I were to take Lynn's notes and go out and photocopy them, I will have done what? I will have infringed Lynn's copyright because she is the only one who can make copies of that work. Okay. We need another person. You look friendly. What's your name?
Chris.
Chris. Are you taking notes?
Yeah.
A little bit. Okay, Chris. Okay. So Chris is taking notes, and in Chris's notes, everyone's name and address are in there because she's got a really great memory, and she writes down everybody's name and address. Those are in Chris's notes. So instead of photocopying them, which would violate this exclusive right to Chris, I go out and I create that stage play that we spoke about. That's a copyright infringement because, assuming her work is creative, I get it, right? That's called a derivative work. So if you go and watch a movie and write a book based on the movie that you saw, that's copyright infringement. If you go, the examples are legion, right? There are multiple examples. But you're the only one who can create a derivative work. And the technical definition is to recast or transform the original work into a different form. That's copyright infringement. Rochelle.
How can so many fan-based books can be published?
Because, yeah, that's a good question. The question was about fan fiction. Number one, the author doesn't care because they like the fact that it's promoting their book, or there has been a lawsuit and it was settled, or the fan fiction page paid money and took a copyright license, or the fan fiction page hasn't been caught yet. It's one of those four things. That's it. Because those are derivative works. You guys all heard J.K. Rowling sued and won, that guy that developed the Harry Potter lexicon. That's a derivative work, and she won. Yeah.
Okay, the creative process as an author, for me,
Yeah.
what I do to create my work is I listen to music, okay? And
Right.
I'm sure there are plenty of authors that do that. I know that my music influences my work.
Right.
So is that crossing the line? To say that this singer is influencing my work, this music influences my work?
Well, sure, let me give you the answer. The answer is it depends on whether it's a derivative work. Now, bear with me. I know, but wait, I'll tell you. Wait, stop. I'll tell you. It's a derivative work if a judge or a jury looking at your resulting work and compared with the original work that inspired you, if it's clear that you've incorporated specific elements from the pre-existing work such that there's a definable connection between the two. And on your facts, if you're just listening to a song, if you don't literally incorporate the lyrics, that's not a derivative work, nor is it copyright infringement. You're free to be inspired, but when you start plagiarizing, of course, then it becomes a derivative work, yeah.
So in my current work, I have part of the song that inspired the character, and so she's saying it, it's going through her mind. Would that be considered derivative work? It's like she's reflecting on a moment, and the song's going through her head, and it's talking about the moment. It's just 2 or 3 lines from the song.
Is she actually thinking about and repeating in the work the actual lines?
She's the actual line.
Okay, that's not a derivative work. That's actual copyright infringement.
Well, that's... So do I attribute that, or how do I...
Here's one. My first mantra is copyright is not a verb, right? You all know that. Guess what my second mantra is? Attribution is not permission. Take it to the bank, kids. Attribution is not permission. So the technically correct answer is you'd have to contact the owner of the copyright and obtain a license, unless you want to try to avail yourself of the fair use doctrine. Okay. You don't understand any of that. I know. But we'll talk about. You don't actually. Bless your heart. I will talk about that in great detail. But what you would try to do is, if you're going to sample, right? That's the analogy here. If you want to sample from a pre-existing work, you can do it. You either have to A, get permission, B, not get caught, C, use the fair use doctrine, or D, do what's called a parody. Parody is a defense under copyright law. And the only one of those that seems to work on your facts is maybe fair use. Maybe. Yeah. Sampling is a really big deal in copyright law. Okay, you're also the only one who can distribute copies of the work. So you can, someone cannot just take your work and go out and sell it and distribute copies of it without your permission. You are the only one who may publicly perform your work, assuming it's publicly performable, like a play or a movie, right? Or a song, Dolly Parton. This is the one that we had. This is why you have to pay ASCAP money right here, this one. Display the work, like for a painting. You're the only one that can hang it in a gallery. Titles and short phrases are not copyrightable. So just get it out of your heads. Book titles are not copyrightable. So you may come up with the coolest title in the world for your book. It's not copyrightable. You have no copyright protection in your book title at all. Sir?
So if you had a photograph and you were going to sell that photograph for lithos, you would have to copyright that photograph.
No, let's work through that. Okay, who took the photograph?
I took.
So you own the copyright. Copyright is not a verb. We're done. You own a copyright. You own a copyright. Now, you are the only one, sir, that may do these 6 things. So what do you want to do with that photo now?
Sell it.
Go right ahead. You're the only one who may distribute copies. Sell it to your heart's content. I, however, may not without your permission. Because
We have to do this in a legal manner, correct?
well, you are doing it in a legal manner. I know this because I'm a lawyer, and you are doing it in a legal manner. You're creating a copyright. You own it. You're the only one that can do these 6 things. That's the law. That's the law of the United States.
How do you protect it?
You hire a lawyer to sue people for copyright infringement. I'm not being facetious. That's what you do. Or either you let it go, you just ignore it, and you grit your teeth, and you say, you stole my work, and there's not a darn thing I can do about it. I'm sorry. Or you hire a lawyer and you sue him for copyright infringement. I have right now 5 pending cases in federal court for copyright infringement. This is what I do. This is what other lawyers do. We make money for people who have had their work stolen, and we sue them for copyright infringement. Lynn?
Is there a legal document to get permission?
There is.
Okay.
Yeah.
And that covers
We'll talk about that. Okay. So those are the only things that you can do. Now, we've already talked about this slide, but now you, I think, have a better understanding of what a copyright is and what those 6 rights are. So now that you understand that, these are some of the questions you should be asking yourselves, and you've already started asking, I can tell. Inbound, can I use the content? Can I right-click and use that? Can I be inspired by that song? Can I do that? You should always ask that question. And regrettably, there are no, as we say in the law, bright line answers. These are all, copyright law, all the areas of law is very fact specific. So ask yourself, may I use the content? And if you cannot, then you need to obtain permission from the copyright holder. Outbound considerations. As the owner of the copyright, you're the only one that can do those 6 things. You need to protect your content, and if you want if you want to let other people do it, you use what's called a license. So you, sir, the gentleman in the back of the room with the photograph, if you want other people to have permission to sell your photograph, you give them this thing. You give them permission, a license to do it. And they pay you money for the right. That's how it works. Yes?
Kind of an inbound question. You know about blog tours?
I do.
Okay. Somebody is interviewing you in a blog tour, and they say, what inspires you? And you quote somebody in a blog tour. How does that work?
Okay, let's just break it down. Every copyright question like that can be addressed by this analysis. Ready? Who is the owner of the copyright? And if it's not you, then you have an issue. That's it. So anytime a client calls me with a copyright law question, I say, who's the owner of the copyright? Who's the author? And if they say, well, not me, then we have a more protracted discussion. If they say me, then I say, well, then you're the only one under, it's 17 U.S.C. Section 106, you're the only one that can do those 6 things. If you're not the author, then we have to have a chat. So in your hypothetical, you quoted something of which you're not the author. Therefore, yes, you have copyright infringement considerations. Sir?
What about public domain?
Oh, we'll talk about that too. Yeah. So yeah, just be patient. Okay, next slide, Marilee. Hey, look at that. It's almost like I paid you money to queue up this slide. That is awesome. Have you been through one of these before? Did you know that was the next slide? Look at that. Who's the author? That's amazing. Okay, so copyright ownership. So the first question we always ask is, who's the author? That's the first question. Everything else flows from that. And if it's not you, meaning you are not demonstrably the person who reduced the sufficiently creative idea onto the tangible medium, you're not the author. You're just not. And so you have to ask, wow, can I actually do this? Can I use this stuff? May I, without getting sued and losing for copyright infringement? So, but this is a tricky piece here. But is the author always the same as the copyright owner? This is where we have to really focus for a minute, kids. The author is the one who reduces it to a tangible medium. That's not always the same as the owner of the copyright because, merely, of what's called the work-for-hire doctrine. And it's really involved, but I'm just going to spit it out. We're going to give it a shot. Ready? Okay, the author owns the copyright unless the author is an employee and the work is created in the course and scope of the employee's work. Then the employer owns the copyright. That's the work-for-hire doctrine. People get it wrong all the time. That is the work-for-hire doctrine. Works created by an employee, within the course and scope of their employment, the copyright is owned by the employer. End of story. Sir.
Going back a little bit, use phrase on the last dot in there, short phrase. Can you define short phrase?
I can. I would say, generally speaking, anything under 25 words may not be protectable in copyright law. Because, and the reason, we should all know the reason. Why? You all know the reason now. Well, you tell him. Lynn, you know the reason. Why isn't a short phrase copyrightable?
Because many people would say it.
No. Keep trying. Because it's not sufficiently creative. See? Yeah, really. It's got to be, but sir, you're not without a remedy. Holy cow, you can use contract law and trademark law. There's all kinds of things you can do to protect that. You just can't use copyright law. Okay? Copyright law doesn't help you there. Yeah, Chris.
In the nonfiction that I write, my publisher says 50 words. You don't have to get assigned permission for less than 50.
Chris, dear, that's a different issue.
Okay.
He's asking about whether or not you can use copyright law to protect a short phrase.
Okay.
You're asking how much of a quote can you use without attribution, without getting sued for copyright infringement and losing.
I thought it was just a different
Different issues, completely different issues.
Okay.
And your publisher, with all due respect, is wrong. There is no bright line test on that.
Okay.
So if you just automatically assume that you can take 49 words and be scot-free, that's wrong. It's just wrong.
Okay, good to know.
Yeah, go ahead.
Most metaphors are just not copyrighted.
Most metaphors are, yes, sir, that's correct. Most metaphors or aphorisms, by extension, are not copyrightable. That is true. Marilee.
What about hiring somebody to do a jingle for a client?
What
And
is
negotiate in advance
Right.
that the jingle belongs to the client,
Right.
even though the jingle writer creates it.
Okay, let's talk about that. So remember now, the general rule is that the copyright is owned by the author. The author is the one who does the reducing. The exception to that is if the author is an employee, and then the employer owns the copyright of works created in the course and scope of their employment. I'm sorry, that's just it. I can't make it any more simple than that. Now, the exception to that is what if you're not an employee? What if you are an independent contractor? Then what happens? Guess what? No. You've got to be careful with that phrase. That phrase is always misused. It's not a work for hire. By definition, it's not a work for hire if it's created by an independent contractor. It's not. Maybe it's a good question. Let me restate that. Just because it's created by an independent contractor specifically does not make it a work for hire. The only thing that's a work for hire is a work created by an employee in the course of scope in their employment. You can shout about that, but that's true. Okay, so the exception, though, is if the work is created by an independent contractor. So you, ma'am, what's your name? Right there, you, in the black. Yeah. Jolynn. Jolynn is hired, and Jolynn's a graphic artist, a very good one, by the way. And Jolynn is hired, I actually don't know that, I'm just assuming that. Okay. Jolynn is hired by a company to create a logo. A very pretty, fanciful, colorful logo with trees and flowers and birds, and it's really pretty, 8.5 by 11 logo. Okay, she's a contractor, not an employee. They pay Lynn Jolynn. They pay Jolynn $5,000 for this logo because she's a very good graphic artist. She delivers it via email as a JPEG file. The person who pays her the money looks at it and says, "This is my logo." They put it on T-shirts. They put it on posters. They do all the things that they think they can do under Section 106, those 5 things. Guess what? Jolynn turns around and sues them for copyright infringement. Guess who wins? Jolynn. Because she owns the copyright. Because she's an independent contractor, and there is no work for hire doctrine in play. You own it. So if any of you have ever created a work as an independent contractor, you own the copyright. Woohoo! Payday. Unless you gave it away in writing. You signed a contract that said, Jolynn hereby gives away the copyright to the guy paying her the money. But many times people don't do that. They don't know to do that. They just think, what's the common thought? They think, I paid for it, therefore I should own it. That's wrong. So, depending on where you are in that hypothetical, if you are an employer, make sure everybody that does your stuff is an employee. If you hire independent contractors, make sure they're all under contract that says you get the stuff. Conversely, if you are a contractor, you should be somewhat clever in your negotiations. You don't have an obligation to say, oh, well, I need to give you my copyrights. When I represent independent contractors like Jolynn, I say, Jolynn, you will own this work unless you want to give it away. The contract is silent on this, Jolynn. Do you want to give away your rights? I'm not going to offer it up. Jolynn's my client. So you negotiate, of course, based on who you represent. Does that make sense? Okay, so regrettably, it's not just as simple as the author is the owner. The author always creates the copyright, but author ownership of the copyright is variable based on these facts. Okay, questions about that? Next slide, please. Okay, here we go. Now, this is where some of you were asking about protecting your copyright. Remember, you own a copyright by virtue of the act of reducing a sufficiently creative idea into or onto a tangible medium. You own a copyright. At that point, you are the only one who may do those 6 things on that other slide. You're the only one that can make derivative works and create copies. You're the only one. But there is a little wrinkle in United States copyright law that says if you want to be able to enforce that copyright that you own through a copyright infringement lawsuit in federal court, you have to register the copyright. This is what most of you think of when you use copyright in a verb sense. This is what you're thinking of. But even this is not the act of copywriting. This is the act of registering an existing copyright that you already own. And you don't have to do it. And it has nothing to do with the Circle C, has nothing to do with mailing it to yourself, nothing. It's a separate exercise that the owner of the copyright may engage in to send a copy of the work and $35 to the Copyright Office in Washington, D.C. and register the copyright. And you must do that if you want to sue people for copyright infringement. If you never, ever, ever, ever want to sue somebody for copyright infringement and you don't care that you don't have a remedy, if somebody uses your stuff, you never need to register a copyright. You own them. You can certainly put Circle C on them if you want. It doesn't mean anything, but you can put a Circle C on there. But see how there's a difference, a very distinct dichotomy between use and registration of a copyright? Does that make sense? Ownership and registration of copyrights, different things. Ownership, registration, different. Rochelle? No, that's fraud on the Copyright Office, and that is illegal. Yep. Yeah. Oh, sorry. She asked if someone else can register the copyright in your work. And the answer is no. Well, obviously not without your permission. You can grant someone permission to do it, Rochelle, but no. For example, if I went to a gallery and saw one of your photos and liked it, and I took a photo of it with my cell phone, and then I took it home and I sought to register the copyright in that as my work, that would be fraud on the Copyright Office. That would be illegal, yeah. Yeah, yes?
Do your novels, can you submit them before they go through the final proof, or do they have to be, can you submit them to the Copyright Office and still make changes to them, or do you have to re-register for copyright?
The question was, at what point do you register your work? And the answer is, copyright law requires you to send in what's called the best edition of a work. So you should wait until you have the best edition, meaning you're essentially done, the final version. The reason is this. You can file as many copyright registration applications as you want. If you file, let's assume you start writing your novel today and you've written 10 pages. You can register the copyright in that, sure. And then you write 20 more pages and you register the copyright in that. Of course you can. But we ultimately want the final thing that's in the repository back in DC to be the version of the work that people are most likely to infringe. Because remember, that's what we're doing here. We're creating a mechanism so you can sue people for copyright infringement. So we want the thing that you register to be the thing that people are most likely to steal. Does that make sense? The best edition.
So the photographs I was talking about, you would register those?
If you wished, yep. Yes, if you wished. You could take those photographs and send them into the Copyright Office with a check for $35 and a registration application form, and you would then have, yes, in those photos, a registered copyright. But you don't, to be clear, you don't have to do that to own the copyright. You only want to do that if you're worried about somebody stealing your photographs.
But it apply to writing much more so than
Sorry?
it apply more to writing, I'm sure, than photographs.
It actually applies to all of the above. You can register copyrights and should in sculptures, photographs, music, choreography. They actually have a means of writing down the steps in choreography. You register copyrights in those all the time. Any work of art that's in which someone can own a copyright, you may register that copyright. Sure, anything.
And is that per, would that be like one photo, or would that be a whole bunch of photos? Or?
That's a very good question. Yeah, the answer is technically it's $35 per work. So if you have 1,000 photographs, you're saying, I can't spend $35,000. But what you do, of course, then, is you put them all into a book. And you register the copyright in the book for $35. Aha, okay, that's what you do. That's what poets do. That's what everybody does. That's what people do. That's what poets do when they have 1,000 poems. You stick it in a book and register the copyright in the book. Yes, ma'am?
You're sending a short story to an anthology. You would own the short story for that. You would own the copyright for that short story. But the publishers of this anthology, where do they came in? Do they?
There's actually an answer to that. Very good question. That's called a collective work under copyright law. So when you, like an anthology is a collective work. So what that is that some editor takes separately individual copyrightable works and puts them together into an anthology. That's called a collective work. You retain ownership of your individual copyright in the contribution to the collective work, but the editor actually has a copyright in the whole work, not in the individual pieces, only in the whole work and in the way they were arranged and ordered and the editorial comments. You retain a separate copyright in your work as part of that collective work, unless you've given it away in a contract. Right? Excellent. Yes, ma'am.
Going back to where you talked about the illegal piracy, if you have a registered copyright for your ebook,
Good.
how do you let someone know that you have a registered copyright so that they are less likely to pirate?
Very good. The Copyright Office maintains a publicly available database in which you may go and look to see if someone has a registered copyright. Most people do not, but they can and they should before they use somebody else's work. So to specifically answer your question, A, you could direct them to the Copyright Office and ask them to look in the database and see that you have a registered copyright, or B, you could physically mail them or send them a copy of your registration certificate, advising them that you have a registered copyright. Or you could actually just not wait and sue them for copyright infringement because you have a registered copyright. There's no need to do any of that preliminary stuff. You could simply just sue them and advise them via the lawsuit that you have a registered copyright. Any one of those.
Can you mark the work? Just as which would
Yes.
give someone a heads up?
Yes, you may. Let's talk about that. You may place the little circle C on your work if you want to. There is no legal requirement that you do it. Your work is not copyrighted if you do, and it's not uncopyrighted if you don't. What matters is whether you own a copyright and you register a copyright. That's it. So to answer your question, if you put a circle C on it, the understanding is that you are claiming a copyright in that thing, but there's no reason you can't also say, this work is a registered copyrighted work by Matilda Jones, all rights reserved. That has no legal efficacy, but sure, put them on notice. The only way to stop somebody is to sue them. Registration alone doesn't stop anybody. Circle C doesn't stop anybody. These are all just steps. Remember, issue spotting and avoidance of liability, these are all just steps to help you protect your intellectual property. Yeah?
If a book is copyrighted and you then later on go into ebook, make it an ebook, is that transferred in any way or is it totally separate document?
Anybody want to help me with that? I think I understood what you were saying. If you've written an ebook.
You've written a book and you copyright it.
What do you mean by that? You've registered the copyright?
You've written a book. You've registered the copyright.
Okay, good.
And then you, registered, I used the wrong term. And then you decide to e-publish it.
Yeah.
Does that registration transfer?
Oh, yeah, very good. That's a very good, yes, the answer is yes. The registration translates across various media. That's a very good question. Yeah, the answer is yes, it does. Now, if you make a movie, it doesn't. You've got to re-register, you've got to register a new copyright in the movie or the stage play. But a book, different media of book, you know, PDF, e-book format, yes, very good question. It does translate, yes. Next slide, please. Okay, we need to talk about these things because we've only got 10 minutes left, and these are very important topics. Public domain and fair use. Let's go to the next slide, please, Marilee. Here is the fair use doctrine. There it is. From the statute. Look at all those horrible, awful words. But let's parse it out and figure out what fair use means, okay? First of all, let's be clear, and you guys don't have to write all this down. Just email me. I'll send it to you. If you want to write it down, knock yourselves out, but I'll send you the deck. I don't care. Okay, so here's what the fair use doctrine is. If you can bring something within the fair use doctrine, it's not copyright infringement. It's not. It's not, and you will win the lawsuit. Okay? But the trick is bringing it within the fair use doctrine. Here's how you do it. First, it's multiple parts. First, the court will look at the purpose of the use. The purpose of the use. Are you using it for purposes like criticism, like Ebert and Roper, comment, like comment, I can't think of an example, news reporting, okay, teaching, including multiple copies for classroom use, scholarship or research? Are you using it for one of those things? Well, are you using it for one of those things? That's the first test. If you're just writing a novel so you can make money and retire, it's not one of those things. It's not. It's got to be one of those things, initially. Yeah, go ahead.
I think I was trying to write a book, my future is to write a book about teaching people to write, and I want to use like paragraphs or examples from novels.
Uh-huh.
So the book itself would be about teaching people how to write. So.
Well, you tell me, is it one of these things? Is it criticism? No. Comment? Maybe. News reporting? No. Teaching? Maybe. Scholarship? Maybe. Research? Maybe. Okay, so maybe. I would say maybe. We could get you into this first prong here. Maybe. But we're not done.
Okay.
Now we have to go down and apply these 4 tests.
Oh.
See? See, it says, shall include, in all cases, in any particular case, shall include, 1, the purpose and character of the use, including whether or not such is for commercial or non-commercial purposes. That's only one of the 4. 2, the nature of the copyrighted work, the one you're stealing from. How strong is the copyright in that work? Is it somebody's recitation of 3.14159, or is it a George Lucas movie? The George Lucas movie has a strong copyright, and you'll lose on prong 2. The pie, you'll win on prong 2. See? 3, the amount and substantiality, how much 3 is how much you used, relative to the work of the whole. So if you, ma'am, use 1 sentence out of a 3,000-page book, you'll win on prong 3. If you use 4 chapters out of a 5-chapter book, you'll lose on prong 3. And lastly, the effect of the use upon, in other words, how much money are you going to steal away from the other guy by using their work? And if they're not going to be harmed at all, in other words, if people will still buy the George Lucas movie despite the fact you've stolen it and made it available for downloading on your website, then you will win on prong 4. I know, but otherwise you'll lose on prong 4. See, that's the fair use doctrine. See how it's always really difficult. People, is this fair use? And I'll say, I don't know. Let's go through the test. Here we go. Number 1, is it for comment? See? Now we've got to apply the 4 factors. So if you just glibly apply the fair use doctrine and say, because somebody told you, oh, it's fair use, that's wrong. It's just flat wrong.
Do you have to meet all 4 of those tests?
You have to win on more than less of the 4. You got to win on 3 of the 4, 2 of the 4. If you only win on 1 of the 4, out of luck. You win on 2 of the 4, maybe, depending on how good your lawyer is. You win on 3 of the 4, and if you win on 4 of the 4, it's probably going to be a fair use, assuming you can stick it into one of those up there. That's it. That's fair use. Yeah.
I'd like you to know if I counted up, it's 250 words. And it came, they sent it to me in the mail and with some opinions. And there was a website, which I can ask them like.
Well, let's analyze that together, since we all now are fledgling copyright lawyers. What's the first question we ask? Very good, sir. Who's the author and owner of the copyright? Is it you?
It'll be them.
Very good. So then, are you proceeding at risk? We know that automatically because you don't own the copyright. Okay. So then, do you have permission? No. That's not permission. That's not permission to infringe their copyright. No, that would. I see your point, but no, that wouldn't work. Okay. So you don't have permission. You're not the owner of the copyright. Is it a fair use? I don't think so, because you're using the whole. Let's go through it. You're using the whole work. You're going to lose on 3. That's pretty creative, copyrightable stuff. You're going to lose on 2 for sure. You might win on 4 because it's a free flyer. But your use, is it a commercial use or is it non-commercial? Your use. Okay, you're going to lose on 3 of the 4. No fair use. I can't think of a way for you to do it. Yeah. Everybody see how that works? It's not magic. That's just the analysis. Yeah, go ahead. Sorry?
They've asked me those questions. What is going to be in and how many words and what
I doubt they will ask you those questions. Very few people really analyze fair use correctly. They may ask you those questions, but I doubt it. They're principally going to add, this is the one people seem to focus on, number 1. Is it commercial or non-commercial? But see, that's only, a little teeny piece of the puzzle. This is what people get stuck on. People call me all the time and say, oh, but it's for my church. It's non-commercial use. I say, well, then call your insurance company and get ready to get sued. Yeah.
So the character quotes a song in a book, mentions a character in a book quotes a song.
Quotes a song.
Quotes a song
Yeah.
in a book. Is that a copyright infringement?
Well, let's go through it. Who owns the copyright in the lyrics? You?
No.
Okay, do you have permission? No. Do you have a license? No. Is it fair use? Well, let's go through it. Is it one of these? Is it a textbook or what is it?
It's a novel.
Okay, so you're going to lose on those. Now let's move to the 4. Okay, purpose and character, it's a commercial use. You're going to lose on 1. Nature of the copyrighted work. Is a song highly copyrightable? Yeah, strong copyright in song lyrics. You're going to lose on that one. You're using the whole song. You're going to lose on... Okay, you might win on 3. 4, is somebody not going to be able to have to buy the sheet music or listen to the song because they read your book instead? Probably not. You might win on these 2. You're going to lose on these 2, and you're not going to bring it into this. You're probably going to not have a fair use on those facts. Do you understand why? Do you understand why? Because you don't own the copyright, you don't have permission, and it's not a fair use.
The titles are not copyrighted, so you can say.
Let's restate that. Short phrases and titles are not subject to copyright protection because they are insufficiently creative, right? Okay, good. You guys are learning this stuff. It's good. Go ahead.
Oh, I'm sorry. I'm confused. So if, like, say you're using your character loves Elvis and he's you have so-and-so is humming Heartbreak Hotel.
Uh-huh.
And you just say Heartbreak Hotel without using any of the quotes or any of the some lyrics.
Well, let's go through it. Do you own the copyright to Heartbreak Hotel? No. It's not magic, right? Is it one of these things? No. Are you using the whole work? No, you're only using the title. But Heartbreak Hotel is pretty darn copyrightable. See, I don't know how to answer it. You just got to go through the analysis.
Give me that slide.
Yeah. All right, we need to move on. Sorry, we need to move on. We need to move on.
Identification purposes, does that include legally giving copies of any work to a non-profit organization?
That would probably be looked at by the court as a non-commercial use, yes. Yes?
I was told, I've just been talking around, I've heard that
Marilee?
there's like a date where there's some time where something becomes public domain, like you're going to quote a Gregorian chant in your books from...
Dude, it's like I paid you money for that. It's like you knew we were short of time and you said, dude, we have to move on to public domain. So I'm going to ask this question. That is awesome. That is a public domain question. That's exact. So here it is. Here's the definition of public domain. This is it from copyright.gov. I didn't make this up. This is from the source, right? The public domain is not a place. A work of authorship is in the public domain if it is no longer under copyright protection because it's so old. Dude, you're right on.
How old?
More than 150 years. It has to have been authored. It has to have been authored more than 150 years ago.
Like
I'm kind of going out on a limb by saying that because there really is no clear answer to that question. I'm just sort of making that up. But I've done this a long time. Generally speaking, 150 years. If you have something that's like 87 years old, call me and we'll figure it out, okay? But for sure, something that's more than 150 years old is probably in the public domain, okay? Or, see the or if it failed to meet the requirements for copyright protection because it is, say it with me, because it lacks sufficient creativity, like pi. This is the pi clause here, okay? Yeah, see, good. See, it's all coming together. So it's either old or it's not creative. If it's old or not creative, then you can probably use it under, it's not fair use. No, I know what you're going to ask. It's different from fair use.
That's a different question.
All right, go ahead.
Conan Doyle, I guess, who did the Sherlock Holmes. I understood that his estate,
No.
kept that going.
You know, the problem is that that's probably under UK copyright law, which is different from US copyright law. Really different. Every country has its own body of copyright laws.
Because I see on even Sherlock Holmes movies, used by permission of blah, 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 blah.
Uruguay has its own copyright laws. Slovenia has its own copyright laws. Brazil has its own copyright laws. So I'm only giving you answers that are good in the US.
I was just curious
Yeah.
about that.
All right, so there's public domain. Okay, last slide. Close. Oh, no, actually not. Oh, yeah, hey, look at that. Now, you know that we didn't even talk about trademarks. Did you notice that? And I stuck trademarks in there, but I figured we wouldn't really even get to it, which is fine. So, like I said, I'll mail you the deck, and if you have a trademark question, call me or email me, and we'll talk about it. But let's just quickly review. What other remaining copyright questions do you have here? Yes?
How do you get permission from someone to use their copyrighted material? Is there a form?
Good. No, there isn't. What you do is you get on the internet and you find out who you think the owner of the copyright is. And you email them or you call them and you ask for permission. There is no short answer. You can start at copyright.gov and see if maybe they have a registered copyright. But does everybody have a registered copyright? So you can start there, but very few copyrights are actually registered. Seriously, very few. Maybe 1%.
And why should you worry about it?
You know the answer to that. Why do you register copyrights? Somebody tell him. Why do you register copyrights? Because?
He wants to be able to defend himself.
Say it louder. You want to be able to have a remedy.
She worry about it if it's not registered.
Oh, because she's only looking for the owner, and that's one source she might look. It's like looking in the phone book for a phone number, and if you can't find it, you look on the internet for the phone number. She's trying to find the owner of a copyright. One place she might look is the database of registered copyrights.
Why should she care about
She doesn't. She doesn't care. She doesn't care. She's just looking for the owner. She does not care.
Kate Stewart for using it anyway, so why didn't she use
Yeah,
it?
you can. It's his.
She does not care if it's registered. She's not interested in that issue. She's merely looking for the owner. And this is just like a phone book of possible copyright owners.
Missing some basic concept here. Now, I thought that you couldn't sue somebody for copyright infringement unless you had registered the copyright.
All true.
Then if
She's only looking because she wants to get permission, and she's just looking in a database to see.
you want to get permission, she can't be sued.
All right, I'm going to have to go down this path, I guess. It's okay. The answer is that you want to do the morally and ethically correct thing. That's it. I don't know how. I mean, that's simply it. Okay. You want to get permission because you don't want to be a cheater and a stealer.
Okay, but there's no legal reason tomorrow. We can
Yeah, but they're the same in my view. I mean, I think they're the same. Maybe you don't disagree, but I think they're the same.
You can take anything from Tom Sawyer and Huckleberry Finn right now. That's probably over 150 years old.
That's a very good example. You know, that's probably actually kind of close, but I bet you that is in the public domain. That's a really good example. I don't know. That's a good one. I bet it is. When was it authored? Do you know what year it was? 1870-ish. It might. I don't know, man. That's close. That's a really good one. I don't know. Okay, yeah. We got to wrap it up here. Well, we're technically out of time, right? So we have a half an hour before the next one starts. Shall I wrap it up and then we can just sit and mingle and let the next guy come in? You want to do that, Kara? All right, we're done. Thank you. Email me, call me. Love you.
For more workshops from the 2011 Idaho Book Extravaganza, or for more information about the 2012 Idaho Book Extravaganza, see www.idahobookextravaganza.com.